Hello, 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 and thank you so much for stopping by. I'm Soraya Marshall Wright. Welcome to The World According to Soraya. All right, so a few weeks back, I posted a video that talked about how all powers of attorney are not created equal. Just to recap, I told you that there's a difference between a general power of attorney and a durable power of attorney. And if you are concerned about being able to plan for long-term care and having an agent who can actually help you if you become incapacitated, you have to have a durable power of attorney. Today, I want to clarify some points that confuse a lot of people. So first thing you should know is that there are actually two types of durable powers of attorney. There is a power of attorney for financial decisions and a power of attorney for healthcare decisions. They are not the same thing. One will allow your loved ones to, of course, take care of your regular business, pay your bills, access your accounts if they need to. The other will give them the authority to make healthcare decisions for you. A lot of people think that having one power of attorney will cover all that, but it does not. The other document that's often confused is the living will. Now, in one of the earlier videos, I shared with you why I felt like your last will and testament was basically a suggested retail tag. Now, a lot of people think that your last will and testament and your living will are the same, or they may think that a living will and a healthcare power of attorney is the same, and they are not. Your living will works right now. Your last will and testament works after your death. Your living will, unlike your healthcare power of attorney, is the document that you would use to explain in great detail how you would like things done. The healthcare power of attorney appoints someone you trust, but the living will says, this is what I want withheld. This is what I want given. This is how long I want to be on life support if that comes up. This is how long I want you to keep me without water and nutrition. If I can no longer feed myself, this is what I want you to do. That's what the living will does. Now, a lot of people say, do I really have to have that? If you don't have a living will and you have a healthcare power of attorney, technically speaking, the person you appoint is in charge of making those decisions on your behalf. And if this is someone you trust, and someone you know will carry out your wishes, you likely won't have any problems. But is that really something you want to put your family through? Do you want them to really be in the ER deciding how long they should keep you on life support or not? Having a living will prevents them from having to make that decision or having to wonder what you yourself would decide. The living will give great details about what you want done if you need life-sustaining treatment. It really happens, it really becomes important when you are on your deathbed. Okay, so just to recap, we have a power of attorney, a durable power of attorney for financial decisions, a separate durable power of attorney for healthcare decisions. Now, you may hear people refer to this as a healthcare proxy. That's the same thing. And lastly, you have a living will. These are three separate, distinct documents that accomplish different things. Again, one will allow your loved ones to manage your regular affairs. The other will give them the authority to make healthcare decisions on your behalf. And the last, the living will tell them exactly what you want to happen if you are on your deathbed and they need to make some very difficult decisions for you. Okay? So if you didn't know there's a difference between the three, now you know. See you next time.